Good afternoon and welcome to Greenfields Solicitors channel with myself, Raheela Hussain. I am a specialist immigration and human rights solicitor and the principal solicitor of Greenfields Solicitors. Thank you again to our audience for logging in and watching us on YouTube channel. I hope you have enjoyed my previous videos and I hope my current video, which is today going to be based on overstayers, case scenarios, will be helpful to members of the public who are interested to learn what immigration applications and what legal avenues are available to people who wish to regulise their legal status in the UK. Now, overstayers can be defined as people who entered the UK, be it on for example, a visit visa or a tier visa, but for one reason or another ended up overstaying the required period that they were supposed to go back. So for example, visas have expiry dates. With visit visas, this is generally a 6-month period. So as an example, one may have entered the UK on the 1st of January 2015 and they were required to leave after 6 months, but they failed to depart for whatever reason to their home country and decided to remain in the UK. So this person will now be classified as an overstayer under the immigration rules. Now, overstayers do unfortunately put themselves in a difficult and precarious situation by not having any lawful status in the UK. Coupled with the fact that they have no lawful right to live and work in the UK, and therefore it would be extremely difficult for them to stay in the UK, there are circumstances where overstayers can successfully make an application to the Home Office to try and obtain lawful status in the UK. Commonly, such an application will be requesting that the Secretary of State grant them a lawful status called discretionary leave to remain. Now, I at Greenfields Solicitors and my team here, we undertake discretionary leave to remain applications on an almost daily basis. We find that we have a very high volume of overstayers in the UK who are seeking to regulise their lawful status. At Greenfields Solicitors, we have vast experience in immigration laws and the Human Rights Act, which assists our clients in often successfully obtaining lawful status. And I cannot tell you how delighted so many of our clients are that after many years of being unlawfully in the UK, they finally achieve success and obtain an endorsement of an initial grant of 2.5 years of discretionary leave to remain, which I should point out is extendable, and it's much easier to extend this discretionary leave once you have lawful status. And after a period of 10 years under the current immigration rules, a migrant can then apply for indefinite leave to remain and eventually naturalisation as a British citizen. So you may be wondering, what kind of overstayers can get lawful status? What kind of cases does the Home Office approve? Well, today I will be discussing some different types of circumstances and real life cases that we have undertaken at Greenfields Solicitors where we have achieved success for our clients. For reasons of confidentiality, we will of course not go into details or names of our clients, so I will just give an overview, and then hopefully this may resonate with those people out there who need assistance to try and make an application for regularisation of legal status. Now, it may be helpful for our audience to refer to our website, which is www.greenfieldsolicitors.com. That's www.greenfieldsolicitors.com, and you will find there is a page dedicated on our website called Case Scenarios. And the kind of cases that I'm going to speak about are also on our website, and it will give you more information. So, I can tell you once I was approached by a Nigerian gentleman and he had no lawful status, having overstayed his visit visa. He was here for many years, 6 years, and during this time he had actually formed a relationship with a British-born English lady, and they had a young son together who was about 2 years old when they came to see me. Now, Greenfields Solicitor submitted an application under the relevant immigration rules and also under the Human Rights Act, and we argued the rights of the child. The child incidentally is a British citizen because his mother was a British-born citizen, so in nationality law the child was able to derive British nationality despite his parents not being married. Now, I'm pleased to say that on the first instance, Greenfields Solicitor successfully obtained for this gentleman an endorsement of discretionary leave to remain for 2.5 years, which meant he was lawful, he was able to work, live, travel, and live as a family man, which is all he really ever wanted to do, and to help provide for his family in the UK. Another example is where people come to Greenfields Solicitors and they say, look, I'm on a current visa, be it a tier 4 or a visit visa or a tier 2 visa, and for whatever reason they're not able to extend their visa, but they wish to remain in the UK. Now, Greenfields Solicitors have undertaken what we call variation applications applications. So we ask that the Home Office grant this migrant person an extension or a variation, I should say, of leave to remain in a different category under, say, the Human Rights Act or outside of the immigration rules. Now, the Human Rights Act, as an overview, is often what we argue at Greenfields Solicitors, and that's under Article 8 of the Human Rights Act, which refers to the right for private and family life. So where a migrant can say, look, please grant me legal status to remain in the home in the UK, please, the Secretary of State, because I have established either a private life or a family life, then the Secretary of State has the discretion to grant that person lawful status, depending on how good the case is presenting, depending on how good their circumstances are, if they refer to the relevant immigration human rights laws and they fall within the criteria. Now, human rights and immigration law is a very, very vast area of law. It's ever evolving, there are changes constantly, and it's difficult to keep up. So I would advise anybody who's looking to make some sort of immigration application to always obtain good, legal, accurate advice before they embark on undertaking any particular type of immigration application, simply to ensure that they have the very best chance for success, as no one obviously would want to risk a refusal. So another client that we had was on a Tier 2 visa, and she was in great difficulty as her employer was unable to sponsor her any further, and she had spent many years in the UK studying on a Tier 4 visa and then obtaining a very good job as a Tier 2 migrant. So she came to Greenfields Solicitors and she asked for our assistance, and the Greenfields Solicitors submitted an application to the Home Office requesting a variation before her then visa expired, and asked that she be granted discretionary leave to remain. This particular client had no family back in her native country, which was one of the countries in Africa, and she was unable to return there because she had no parents who had passed, no siblings who were in a position to care for or provide for her, and she had spent so many years in the UK that she had really considered and made a life for herself in the UK, including a relationship. Now, what happened there was the Home Office unfortunately refused this application, but not to be deterred upon our advice, Greenfields Solicitors represented in an in-country appeal, and at the appeal I'm delighted to inform you that the client was successful and the immigration judge actually granted her discretionary leave to remain, again initially for a 2.5-year period. This particular client had no children, she was unmarried, so as a single person she successfully argued Article 8 of the Human Rights Act, and also with reference to paragraph 276 AD of the immigration rules, an argument was made and we were successful in obtaining her leave to remain. Another kind of case that often results in discretionary leave to remain is where there are children involved. So where a migrant has children, where they have British children or children who have indefinite leave to remain in the UK, where it can be shown that the migrant should take a parental role in that child's life, and it would be very, very wrong and very disproportionate to expect the migrant not to continue their family life in the UK with that child, then an application can be made to the Home Office for the migrant to obtain discretionary leave to remain on the basis that they have the right to live with their British child or have even access or contact to the British child if, for example, the child lives with its mother or father or another parent. So it's not always necessary for the migrant to have full custody of that British child or settled child, but it is important that they play a parental role. So we've had many clients in such situations, and I'm pleased to say Greenfields Solicitors have an extremely high success record in obtaining lawful status for these people and regularising them so that they may live as a helpful member of society. Now, we've also had cases where people are carers for family members in the UK, so where it can be shown they have a family member in the UK and the migrant is responsible for the care and the day-to-day help for this person, it's possible to make an application for discretionary leave to remain. Also, there are lots of different other types of applications where Greenfields Solicitors have been successful. For example, there have been migrants who've come in on 6-month visit visas and then they've sought to remain in the UK outside of the immigration rules based on various factors. For example, we had one lady from the Far East, and she was married to a British gentleman and had a child, a young child, and she came into the UK on a visit visa, and during this time it was agreed between her and her husband that they would want to continue with living in the UK despite living in the Far East for many years, and an application was made to the Home Office. Now, the normal route would have been for the lady to have gone back to the Far East and apply for a spouse visa, but again Greenfields Solicitors made an application under the Human Rights Act with reference to Article 8 of the part with regards to family life, and the Home Office successfully granted her an endorsement of 2.5 years, thereby giving her lawful status and allowing the family to remain in the UK. Now, there are instances where people have bad immigration history, so they may have also criminal convictions or civil judgments. We would always inform people to be very honest and open with the Home Office, to never deceive any authority, as it's extremely important that the Home Office have all information to hand. Often, I can tell you in practice, where a migrant chooses not to give information that's important or deceives the Home Office, then this can be a refusal in their application, and also be liable to a ban of up to 10 years for providing false information and deception. So at all instances, it's really important to be honest and advise, and if you are unsure when you're making an application, then you really should try and obtain legal advice before doing so. So there are many cases that I could speak about with regards to overstayers and case scenarios, and also variation cases where one has lawful status but then wishes to remain in the UK because they feel they cannot or will not go back to their native country. Illegal entrants are also another area where Greenfields Solicitors help. They too have entered the UK illegally and they wish to regulise. Again, they may have established a family life, and therefore there are merits and there are grounds to argue to the Home Office for them to also get discretionary leave to remain. Sometimes the Home Office, if they refuse an application, they do give in-country rights of appeal, so it's possible for the person to argue their case before an immigration judge if they're unsuccessful in the first instance, or it's sometimes possible if the Home Office refuses to lodge a judicial review action before the High Court, so the decision is overturned. So one should never feel, oh, if they're dismissed in the first instance, there is no other legal avenue to try and succeed. There are many routes, many avenues that a person can take if they have been refused an application. Again, I would stress the importance of getting good legal advice. Well, I hope this topic has been of interest to our audience, and should anyone need immigration or human rights advice, then please do call us on 0208 884 1166. We are open Monday to Friday, 9:30 to 5:30. We do offer telephone consultations as well, so if you are in need of legal advice and you cannot attend our offices in North London, we can offer you 40-minute advice over the telephone, which is currently at a very low cost, and you can learn more about that by going to our website at www.greenfieldsolicitors.com. Well, I thank you for listening and watching our video again today, the Greenfields Solicitors on YouTube, and we look very much forward to seeing you again in the near future. And we would ask all our audience and members of the public to take good care. Thank you.